Well, welcome back to another Cordell Cordell Town Hall regarding tips for guys going through divorce and issues regarding family law before, during, and after divorce, and all matters regarding family law. I'm Scott Trout, CEO and Managing Partner of Cordell Cordell. Today, we're going to bring you 5 more mistakes that guys make when facing divorce. If you've watched us before, listened to our podcast, or appeared in our live seminars that we've done around the country, you would see our 10 stupidest mistakes guys make when facing divorce. Well, we've done 5 more several weeks ago. We're going to do another 5 and go through those with our panel of Cordell and Cordell attorneys today. I'll introduce those attorneys here in just a moment, but keep in mind, stick around for our live question lightning round at the second half of our town hall today. Now, keep in mind that this does not create an attorney-client relationship. We don't want you to get any legal advice here today. But what I do want you to do, get a piece of paper, get a pen or a pencil, start taking some notes. We want to make sure that you can take these down as talking points. We want you to go ahead and seek the counsel of an attorney, particularly one that practices exclusively in family law. We're going to talk about that, obviously, as one of our mistakes, and making sure you pick the right attorney. We're going to come out of the box talking about that as well. But it's very important to understand that limited licensure for myself, Missouri and Illinois and Georgia, and our panel has limited licensure as well. We have people around the United States and the world watching today, and we can't give you the particular advice because your facts and your circumstances would dictate perhaps something different. So, as we always talk about, we're available for consultations virtually and telephonically and in person where appropriate, considering health and safety. But if you want to do that, you can give us a call at 866-DADS-LAW or find us on the web at cordellcordell.com. Also, you can continue to send those questions to me at coronavirus.divorce@cordelllaw.com. That's coronavirus.divorce@cordelllaw.com. Twice a week, I'll address some of those questions that are submitted to me in our podcast, where we also spend about 20 minutes with an attorney on some spot issues. Tune into our YouTube page, and you can find some of those podcasts online, or you can find it on social media, Cordell Cordell, on Facebook as well. And check us out on our webpage again, cordellcordell.com. So let's introduce our panel today, and then we're going to take a very brief break and we get right into our 5 more mistakes. So let's go to Bedford, New Hampshire. Jessica, welcome.
Hi, Scott. Thanks for having me. My name is Jessica Ugarte. I am here in Bedford, New Hampshire. I've been practicing family law for about 11 years now, and just enjoying my summer helping people figure out homeschooling.
Yeah, it just continues as we go through. We're in like week 22 post-COVID-19, and we've been doing this virtual town hall for quite a while now, and things continue to change. So we'll address another one next month, and hopefully we just get past this COVID-19 and some of the shutdowns in schools. So thanks, Jessica. Cassandra, out in San Diego, California, welcome.
Hi, Scott. My name is Cassandra Lelek, and I've been practicing for a bit over 10 years. And with the military population in San Diego, I really like helping our guys that are here. And thanks for having me.
Thanks, Cassandra. Let's go to Independence, Ohio, just outside of Cleveland. Robert, welcome.
Thanks, Scott. Rob Vizmeg here from Cleveland, Ohio, sitting here either eagerly or dreading the upcoming Cleveland Browns season, hoping for the best, but we shall see.
Yeah, we shall see if we even have a season. Who knows, right? That'll be interesting. Maybe you'll go undefeated if the season's canceled.
That's right.
Yeah. Let's round out our panel in Richmond, Virginia with Jacob. Welcome.
Hey, Scott. I'm Jacob Smith. I'm in our Richmond, Virginia office. I'm licensed in Utah and Virginia. In the past, I've done a bunch of mock trial for high school, coaching for high school. I've taken Utah's team to nationals a couple times. I like being in the courtroom and presenting the best case we can for guys that have been practicing 8 years.
Thanks, Jacob. Well, we've tried to bring you some attorneys from all corners of the country, and I think we've done that today. We're going to try to answer some of the continuing questions that we have done over the last 20 plus weeks, and that is, what can you do, what should you do, what must you do? We're going to do that today, albeit we're going to talk about 5 mistakes that guys have made when facing divorce, really designed from my experiences in court, as well as some of the attorneys at Cordell and Cordell. So get your pen and paper ready to take some notes. But first, let's take a quick break and we'll be right back.
Even in the toughest of times, there are usually opportunities for relief. Many husbands and dads listening now are struggling to stay current on alimony and child support orders. You should know that this crisis may allow you to modify your support obligations, but time is of the essence. If you're a guy needing help right now, not someday when things are back to normal, call us at Cordell Cordell. This is what we do.
All right, welcome back. Let's get right to the 5 more mistakes that guys make when facing divorce. Again, we're going to always continually tell you, seek the advice of counsel after today. We want to make sure they get the facts and circumstances regarding your case. All right, Jacob, these are in no particular order. You know, we talk a little bit about a lot of the mistakes that guys have made. I've been doing this for 27 years and I've seen a lot of them. You know, by all means, there aren't just 10 and there aren't just 5, there are a lot. And, you know, I know that your topic, and if you've attended my seminars or if you listened to the 5 previous mistakes guys have made, if you're watching out there and you're a repeat viewer, I use a lot of themes, things that you can use to remember some of these topics and some of these mistakes. And I know, Jacob, yours is choosing the wrong lawyer or really finding the right one. And you've got a theme that guys will undoubtedly remember this one.
Right. Yeah. So the theme is to not choose a crap attorney. So acronym CRAP stands for community, reviews, aggression, and promises. So very first, community, your family, your friends, your church fellow worshipers, club members, gym buddies, and especially your ex are not your attorney. I've had a number of new clients recently who take hold of something that one of these community members has said, and they get stuck on this issue, which is actually bad legal advice. And I'd even extend this to social media groups. I was a solo practice attorney for a couple years before I came on with Cordell, and I got a number of clients from this Facebook mommy group. All these moms would get on and they would just bash their husbands or their baby dads, and they give each other kind of really crazy advice. It worked out well for me. I got a number of clients and made some money from it. But the only advice I would say to take from any of these community members is to seek the advice of an attorney.
Yeah, I think community, you're right. You know, it's always, I get well, my friend, he has the same thing and he got a better deal than I'm getting. You know, they're hearing, it's the backseat lawyer, it's, I play a lawyer on TV. It is difficult. And every case is unique. You have a different judge, you have a different opposing counsel, you have some tweak of facts that everyone forgets. And it is the one thing that I've learned in 27 years doing this is I don't think I've seen an identical case ever. There's always something new, and that's what makes it refreshing. And my practice is a challenge in every case. And so I think you're right, community and taking advice from friends, family, coworkers, church. It's just a mistake. Take it, as you suggest, with a grain of salt, and then use it as a speaking point, just like this. It's this conversation is, don't take it for gospel. Use it to create, a conversation about developing a strategy. And then moving on to your R, reviews. I mean, that's a huge one, right?
Yeah, exactly. With Google and Yelp and Facebook and just the online presence that we have significantly more opportunities to review attorneys. Now, finding an attorney that has good reviews is essential. But as you're looking at the reviews, be aware that really good attorneys aren't going to please all of their clients 100% of the time, right? That's what we strive for, but even great attorneys are going to have a bad review. And on the flip side, some really bad attorneys are going to have good reviews too. So as you're reading these reviews and researching the attorneys, look at multiple sites like Google, Yelp, Avo, maybe Rocket Lawyer. There are a lot of different places you can go on to get reviews of attorneys, and even go try and look back as far as you can. It's very possible that an attorney had a bad review 5 years ago, but now is actually way better. Yeah. It's also possible that attorney had good reviews a couple years ago, now has a lot of recent bad reviews. So keep all of that in mind as you're looking at the reviews. This is part of your due diligence in choosing a good attorney. Read reviews, talk to other people, right? You may have gotten a referral from one of your community. Now go follow it up with some reviews.
Yeah, I do think reviews, we put a lot of stake in reviews for our own attorneys in the firm, but you do have to understand, we've represented hundreds of thousands of clients, and you may find 132 reviews online. There are some websites that really focus only on the negative, and they make sure to delete the positive. And so you do have to take it. It's like when I look at doctors, do I look at reviews? Sure. But I think as you suggest, it is one part to consider, and I want people to interview the attorney because that relationship should be like a doctor. You trust them with your life, you trust your lawyer with everything you've earned, your property, and your kids. And so it's a good starting point to understand, and I think you make a good point here. Aggression in your acronym, I think that's also equally important. We profess intelligent aggression, but what do you think?
Especially when you have maybe a more highly confrontational situation, people will say, you need to find an aggressive attorney, find the bulldog, find the pit bull. A lot of times, at least the way I see it, that's code word for the attorney's kind of a jerk, right? Not the kind of person you necessarily want to have as your attorney.
Yeah.
I think you also need to look kind of on the flip side. You don't want someone too aggressive, but you also don't want someone that's just going to be walked over. Some attorneys, particularly in family law, are looking more at this from a collaborative approach. So when you're researching, you see a collaborative lawyer or a lawyer that's collaboratively trained. Be aware that that attorney may not actually like to go to court, and they like more of the, let's do the mediation, let's really work this out outside of court. Absolutely some benefits to that, and that's always an option. And frankly, sometimes the better option, but you don't want that attorney that's just going to be kind of a sheep in all of this. I think if you've seen American Sniper about Chris Kyle, you'll recall at the beginning of the movie, his dad is telling him that there are three kinds of people in the world. You have the wolves that prey on the weak, the sheep. You have the sheep who can't stand up for themselves. And then you have the sheepdog, right, who stands up to the wolf to protect the sheep. You're looking for an attorney that, when it's absolutely necessary, can go into court, will make objections, will be well prepared, will stand toe-to-toe with that wolf, with that jerk, that bulldog attorney, but at the same time can reasonably and even agreeably help you come to a resolution on your case without litigation, if that's what you choose.
Yeah, the unapologetically stepping on toes, but doing it in a smart manner. That's what we always talk about. And then kind of rounding out, finding the right one, promises. I can tell you before you talk about this, it reminds me early in my career, I was in a deposition. I went into the office of opposing counsel, and he had this almost scoreboard behind him, and it said wins like 152, losses 1. A little misleading. No one keeps score, and if they do, I would question it, right?
Absolutely. I would. Unfortunately, I think it's hard to say that there's ever a winner in family law, because you're losing something. And sometimes you get everything you want, but a lot of times there's going to be some give and some take, and some wins and some losses. So if you do come across an attorney or meet with an attorney that starts to make some promises as to the outcome of the case, that's a big red flag to turn around and run away. Yeah,
there's just so few opportunities to make a guarantee. I mean, they're just minimal. I mean, we like to say, a likelihood of success is more appropriate than promises, which, in terms of giving the right information, attorneys have to make sure that their clients provide accurate information, that they don't hide things, and they can try to give good promises, right? I mean, so it's an important thing. Yeah, exactly. I think what you're looking for is an attorney that can give you an honest, objective assessment of your case, right? This often means maybe hearing something that you don't want to hear, but
But to get that real honest assessment, you have to be completely honest and upfront with your attorney right from the get-go.
Yeah, and that's a good transition, in terms of our next mistake, which is really concealing information from your attorney. Jessica, we've kind of walked right through into this next one, which a great transition to it, which I've talked a lot about in our evening seminars. And my theme was always doctor versus lawyer, and that, patients are always upfront and honest and probably give too much information to their doctor because they feel like everything's on the line, when perhaps sometimes you don't see that with lawyers and clients. So concealing information from your lawyer, another mistake, right?
Right, absolutely. So I always say at the first instance, you want to tell your lawyer everything that they need to know, because our job is to help you. And just like the doctor can't help you if you never tell them you have the symptoms. So they're not going to just have this crystal ball and figure out that you have this $1 million asset that you never told us about. Disclosing information. So our job is to get all that information out, to advise you on that information, and find a way to get you to move on with your life with all of your assets and liabilities in place in a reasonable manner. So if you have something that you're scared to talk about because you think it's going to look bad, if you think you're going to lose all of it, you need to get that out on the table. So one of the things in our consultations, I said, so what else? What would somebody else tell me? What is your primary concern? We go through all of the assets. So the worst thing that you can have happen is you tighten up, you don't talk about it, and then it's found out in court. So let's say you have, your spouse knows that you put cash in the mattress, and it's going to come out and everyone's going to figure it out. Just realize that at the end of the day, everyone's going to figure it out. There are so many ways to find out about assets, to find about property, and to, especially self-employed people. Self-employed people have a benefit of really a lot of deductions on taxes. You want to make sure that you are putting your best foot forward, because your financials get filed with the court. So you need to make sure you disclose those. If I know everything that I need to know, I can help you manage that process and protect those assets and talk about trading some of those assets out for other information. So there are ways to work around it. So if you're worried about losing, if you're worried about things looking bad, it's better to be honest with your attorney. I've had a time where I've been in court and a client didn't disclose on their financial, and they'd been my client for some period of time, and it came out as a surprise that they in fact were hiding an asset. They put it under another name, but the judge said, nope, that's yours. So not only do you now not have the good standing with the court's going to look badly upon any of your requests, because are you being honest? Mm-hmm. So I always ask the questions of my clients, let's fully disclose. What are your biggest concerns? And what is the worst thing that somebody's going to say about you? And that way I know everything, because I can make it work for the client.
Yeah, it's a tough one.
Yeah.
It's simply because we're dealing with, it's weird. I have a couple of friends who are doctors, and they get all that information, and almost as if the most embarrassing moments don't become embarrassing to a patient because they want to be healed. And so if guys are watching right now, and if they take the position that they want to be healed, right, that they want to be made whole to the extent possible, it is embarrassing. We get it. But it's funny. I've had guys come to me and say, all right, now buckle in, because you probably never heard this before. They say it and I go, heard it, and they're like, what? I'm like, yeah, I've heard it all. I've been doing this for too long. And there's really rarely a time when I'm very surprised, but I can tell them that's why you need to tell us, because we can take the smallest of things and use it to your advantage.
Right. I always say to clients, truth is stranger than fiction. And when it's all out on the plate, we can divide that pie any way we want. But if we don't know what's out there, then we can't help you. And there's nothing worse than at the end of the case, clients saying, well, I didn't know I was going to lose that. Well, I didn't know you had that. So we don't want to get in that situation. So over my years of experience, I really, a little bit of boot camp drill. What else is there? What else is there? What else do I need to know? Your relationship with your lawyer has to be another best friend for a period of time. So you want to make sure that you help your clients help you as well, put a good impression out there, because the better relationship we have, the better I can do for them.
As I say, it is a likability contest. Judges are going to look at your client right away and make an assessment, just like all of us. That is kind of the failure that we have as, humans, is we make immediate judgments on people, the way that they look, the way that they speak, where they're from, what they're dressed, the way they walk, they talk, you name it. And so that's why it's about preparation, but it's also about making sure you don't withhold anything, as you suggest, because it does affect credibility.
Right. And I think that goes back to the topic we just had as well about choosing the right lawyer.
Mm-hmm.
You might get a bulldog of a lawyer, but they might not have a good candor with the court. They might not have a good reputation with the court because they're too much of a bulldog. So you don't want to be extreme. You don't want to be walked over. But so it's helpful to the clients that the clients tell you everything, you tell them everything, and then you work together as a team and you put your best foot forward in front of the judge if you have to get there.
Absolutely. I mean, Robert, this kind of transitions as well as we talk about financial records. One of the mistakes guys make is doing a sloppy job on financial records, but it also means that they may withhold some information on their financial. We've kind of alluded to that, but Robert, I want to get your take on whether, this mistake in terms of financial records and being sloppy.
Yeah, absolutely, Scott. In some respects, it's some of the most important things you can do in court is being completely clear and deliberate when it comes to your financial records. It really comes down to two things when we're talking about financial records. As alluded to, credibility, and in the alternative, penalty. I'm going to talk about both of these. In terms of credibility, we have, at least in my jurisdiction, I would presume in most across the country, one of the initial documents that you're going to file with the court is what's known as an affidavit of income and expenses. That affidavit is as if under oath. And so it's going to ask you to fill in information about your income, what your debts are, your student loans, credit cards, et cetera, to paint a picture of what your financial situation is with the court. Ultimately, you want to be as clear and concise and truthful as you can, because these initial filings will have an impact on some of the early orders, temporary support to both child and spousal potentially. And so you don't want to fall behind because you did an inadequate job of filling out the affidavits. As it relates directly to credibility, these documents, because they're under oath, are really great fodder for cross-examination. Mm-hmm. I almost in every single case am able to pick apart the other side because of the number they put down in the affidavits that they filed. And that is going to have an impact on the court when we talk about credibility and this likability contest that really is part of this divorce process. Judges will look to see who they believe is being more credible and truthful and will lend more credence to their testimony. On the flip side, clients tell me, well, she doesn't know about this account. Why? We'll just ignore it and it'll go away. Maybe, but unlikely. As was alluded to earlier, there are a lot of ways in order to discover information. And the unfortunate reality is if you are being dishonest as it relates to your financials, and more specifically assets that you might have that your spouse doesn't know about, the penalties can be severe. I think we all know individuals who have gone through a divorce before. And I think if asked, 0 would say they would want to go through it again. Mm-hmm. And one of the penalties for failing to disclose a substantial asset is that the case gets reopened. In addition to the case getting reopened, there are additional penalties. For example, in the state of Ohio and other states, there can be an award of double or triple damages based on your withholding of that asset that should have been divided. So at the end of the day, as much as an individual might want to be a little bit vague in the things they have, ultimately, it is going to have a detrimental impact on your case. There is no use in withholding something when it has to be dealt with. And unless we know about it as your counsel, we can't give you the best advice possible to try and preserve as much of a particular asset as we can.
Yeah, and I think we don't want to undersell this mistake. And I always give this example in my seminars in the evening. It's from a case, excuse me, that I had in Georgia. And as you mentioned, doing a sloppy job, I almost expected 99% of the time on the other side, just because at Cordell, we've focused so much on this issue. That's why I called it the tax return in my evening seminars, because none of us want to make a mistake on our taxes. But this case, and why it's so devastating, I was in Georgia trying a case over 5 or 6 days, and I was cross-examining the wife for like a day and a half on her financials. It was a maintenance case, a child support case. She wanted attorney's fees, you name it. So we did spend enough time going through it. And I knew I was scoring points. I could just read the judge. He was taking notes, kind of nodding his head as I was finding that she was, acknowledging some of the errors, intentional or not. And then by the end of my examination, opposing counsel gets up to try to rehabilitate his client. Judge picks up a newspaper and starts reading it. And I knew at that point I had it. And at the end of the day, the opposing counsel had said, look, Judge, I just want to make sure you could hear everything I was saying. And the judge goes, oh, yeah, I heard plenty and enough. And it was the judge that made the decision. Now, it's tough to get to that point when you are cross-examining a spouse. But for guys, I always say this, they have an opportunity, and it's one mistake and they're done. And I really believe that. And that's part of the difficulty in representing guys. That's why when we focus on representing men, that's our experience, and we know how to prepare guys to do that and tell you this mistake. And you can't afford to make one because you're a liar. If your spouse makes it, as you suggested, I think a minute ago, she doesn't know about it. She just wasn't involved. And so they kind of give that leeway, right? And I think that's the key here. Is the takeaway is, credibility. Representing guys, they can't afford it, can they, Robert?
No. What you said there is spot on in terms of how the courts will filter out errors on the part of fathers and errors on the part of mothers.
Mm-hmm.
I mean, it's slightly off topic, but I say this to every one of my clients. If your spouse lashes out at you, they are deemed and seen by the court as being strong and independent. Whereas if you lash out in any way against your spouse, you're just a bully. So we always have to be on better behavior as men going through this divorce process. And that, again, applies to these financial records. I think you've said it before, and I think it's a fantastic way to look at it. We all spend an inordinate amount of time making sure that every decimal point is in the right place when we do our taxes annually, with the understanding that we never want to get audited. I can truthfully say, I don't think I've ever met an individual who has been audited.
Mm-hmm.
But I will tell you that you will receive scrutiny on the financial documents that you file with the court. You will be audited by that opposing counsel, and you will have to answer for every number that's in there.
Right.
The truth will set you free. So we at Cordell will focus very, very strictly in making sure that the numbers are accurate.
Yeah, accurate and complete and full. I mean, I think that's just a great advice. And we could probably spend the full 60 minutes talking about this topic, Robert, but I appreciate it. Let's go on to Cassandra. Talking too much, again, that's kind of a good transition. We could talk a lot about it. But Cassandra, one of the mistakes guys make is talking too much, and especially to your spouse or your wife. And I don't mean, and I always caution this doesn't mean stop talking to your spouse about custody and legal custody and joint decision making and health and education and welfare. It really is about strategy, right? And so what do you say?
Well, I like to tell my clients when they come in that consider my office like the Fight Club. The first rule of Fight Club is we don't talk about Fight Club.
Mm-hmm.
We don't talk about what happens in this office. And I understand a lot of people, when they come in with their attorney, you get a strategy and you love the strategy. You're really excited about how you're going to do it. So you want to go tell your friends and you want to go tell everybody, hey, this is our strategy. It's really, really great. But then that can get back to your spouse, and your spouse is then going to know what your strategy is. And so the best strategy is one that's secret. So it needs to be secret from everybody, most especially your spouse. And I understand, and we all understand the desire when you're excited about something to poke at your ex that's going to be your ex and say, oh, well, we've got something. But that's not how we play the game. You want to make sure that you keep the lines of communication open. You want to talk about it, but you want to listen more than you talk. You want to hear what they're saying. You want to get them to talk. You don't want to give away what you have. You want to see what they're going to give away on their end. and you want to sit there and listen. And when you're doing that, you're taking notes. The other thing people like to do is people like to talk about settlements over text message or email. We never put any thoughts about any type of settlement in email, because those can be brought into court, and then the court can look at it and say, well, look, you're saying right now you want full custody, but in this email you're telling her that you don't want full custody and you can't handle these children and you need her to come get them. So make sure that when you're talking or you are talking about these issues, you're doing so in person or on the phone in a way that's not going to be brought back to kick you in the butt. You also don't really want to make any promises. There's a lot of people that want to say, well, I didn't promise in writing. Well, it doesn't matter. It doesn't always have to be in writing. The court is going to take into account what you've been promising, what you've been saying. And if you continue to push that forward with your spouse, it's not helping you to promise them something you don't want to give them. It's actually going to hurt you, because they're going to say, well, look, he didn't mind giving it up then, so why are we making a big deal of it now?
Totally. You know, in the seminars, I talk about Texas Hold'em. This is my theme. I love the Fight Club reference because that's an absolute. You know, you don't talk about Fight Club. I think it's awesome. So guys need to write that down, because cases can be lost in this topic, period. I mean, I know we keep saying that on these mistakes, that they're won and lost, but this is so crucial. I've got all kinds of examples where my client's spoken too much about it, but that's why I use Texas Hold'em as my example strategy. If you've got aces that you're dealt, no one, I mean, if you ever watch World Series of Poker, no one's really talking at the table other than they're bluffing. They're not talking about what they really have. And that really is, I mean, not to denigrate marriage and the sanctity of it, but the point is it really becomes almost like a business transaction when you're going through divorce and you're trying to negotiate and bluff and position, and everyone's trying to get something better. And typically you're not going to get something better with the truth and exposing it in your strategy unless you're at trial. And I just don't like sharing strategy. I think that's a great thing. And I think you talk about never putting anything in writing is also something that's huge. But they are, lost. I think it's clearly, don't you agree, that cases can be lost immediately talking too much?
And I've had cases that have done that, where we get a client that gets so excited about what we've decided as our strategy or something that I've found, and they want to tell them, I've got you. Mm-hmm. And then you tell them and you give them a heads up, and then they're able to fix it in time, that when we get to trial, it's no longer an issue that would have been a slam dunk if you would have just not said anything.
Well, let me get to our last mistake. Now, Jessica, we talked about talking too much. And that can actually transition into the last mistake for today, which is being ill-prepared for testimony interviews. You can talk too much, you can talk not enough, you can be ill-prepared. Tell guys, what they should do to avoid making this mistake that many have already made.
Yeah, oftentimes a lot of these family cases don't get into a testimony situation, right? Most of these cases settle, maybe you go to a hearing, but if you find yourself in a position that you are going to testify in front of a judge and you are going to be cross-examined by the opposing counsel, you need to be prepared. That is where cases are won or lost. So there's nothing worse than seeing your client on the stand and opposing counsel goes to talk to them and they freeze and they can't answer and they can't even figure out which end is up. So you need to take the time to sit down with your client and go through a mock trial, pretend to be opposing counsel, be aggressive, ask the tricky questions. And what I always tell the clients is listen more than you talk on cross-examination. Listen to the words that you're being asked. Answer that question. If you don't understand, that's okay. Ask for clarification. So clients, as humans, we want to explain ourselves. We want to talk it through. We want to tell the judge our side of the story. Cross-examination is not the time. That is my job. That was our time before. Be quiet. And it's because as an attorney doing the cross-examination, there's nothing I love more than a client who wants to explain themselves. And then I'm going to ask another question. And then I'm going to ask another question. Before you know it, I've gotten my testimony in again through opposing client. So be careful on cross-examination. An attorney who's good will be very diligent on making sure that you know the yes, no, I don't know of cross-examination so that you don't seem vague, but you're not giving away information that they just don't need, that it's their job to get that information in. And it's just extremely important because once it's said, you can object, you can try to clarify the record. But once something's said in court, it's done. It's on the record. And the judge can strike it, but we all know it's already been heard. So the value of striking information from the record it's just not what it would appear to be. It's already out there. So being prepared for cross-examination is key to any trial.
Yeah, and I want to come back to you, Cassandra, because I think, preparing, what I think family law tends to be plagued with is perhaps attorneys that don't want to go to trial, don't know how to prepare their clients well in advance. I can tell you, I've seen attorneys walking in the door saying, oh, I just need 20, 30 minutes to talk to my client. Well, I know they're preparing their client, in the side room. So Cassandra, if you're going to talk to guys about this mistake and trying to avoid it, I mean, what do they really need to know what they need to say and what evidence they need to get out?
Yes, so Jessica hit on the cross-examination, which is incredibly important. But the first step that we're always going to do is we're always going to do a direct exam of our client. This is where we put our client on the stand and we're setting the stage for our case. We want our story to be told. We want the judge to hear from our client about all of the things that they've been through. And so what we have to always do is do a dry run. When I work with my clients, I ask them the questions and I get their answer. And we don't change their answer, but the phrasing of an answer can win or lose your case also. By saying what happened that day and a client going off on, what they ate for breakfast and then what they ate for lunch is a lot different than when you're saying what happened that day. And they say, well, she absconded with my child and kidnapped him and took him to a different state. That is a lot more visual for the court to see what exactly happened. It's direct, it's to the point. I'm going to tell you what we're trying to get with this question. So you're prepared to give the court the facts we need, not an idea, not a misunderstanding, the facts that the court needs to make the decision to rule in our favor. And if you're not ready to do that, when I ask a question, you're not going to know what the answer is or what we're trying to get. And so we have to prepare you so that you're ready and your answers come quickly. That's another thing. If you have to wait too long to think of something, the court is then deciding on your credibility. If you already know the answer, the court's already like, okay, they've got this. They know this is exactly what happened.
Right. And I think this ending on this mistake, being prepared for testimony and interviews with guardians ad litem, even depositions from the opposing counsel. I think we talk about, all of this and that, winds up integrating the previous four things, including making sure you don't share strategy, making sure that you have your financials and you're knowledgeable about them, that you also then talk to your lawyer about everything, because you can't be prepared if you're withholding something, because ultimately it's going to come out. It's going to be a surprise for your attorney who really won't know what to do. And so I think that's a great way to end the five mistakes and kind of transition right now. Let's go right to our live question and answer round where we have some questions already. So let's go right real quickly. We can spend the last 15 minutes of our time together answering some questions. So Mark in Texas has a question, and I'm going to give this to, let's go Jessica. I'm going to give this to you, even though you're not in Texas. Mark has a couple points here. Mark says, I have repeatedly been denied custody of my son. Every time this happens, I file a police report. I have 4 police reports and expect to have a 5th one tomorrow. What will the report do for me when I decide to go back to court? Which raises a question of both timing, when should Mark go back and what will it do? And then Mark is also paying for additional dental insurance that my child support was supposed to cover. Mark just wants to know a couple things of what he should be doing. So Jessica, what do you think?
Yeah, the first thing that you need to know is that if you have a parenting plan, I'm not from Texas, I don't know what they call them down there, but if you have a parenting plan that gives you your children at a specific time, and there's documentation by the police that she's not giving you the children, then that is called a contempt. So what I would do is I'd get into court with all these police reports and I wouldn't wait. The longer you let her behavior become a pattern, the judge can say, well, what do you want me to do? This is just what she's doing and you've accepted the pattern. And the police as well are probably starting to get a little frustrated trying to implement your parenting plan.
Mm-hmm.
So I would immediately get in before the court on either a modification if you have a parenting plan. I know here in New Hampshire, one of the standards is frequent interference with the other parent's parenting time is a reason to modify. So you want to contact somebody local and find out if that's in fact a reason to modify. You delaying getting into court is approving of her bad behavior. Although you are going to the police, that is a positive. You are at least saying, I don't agree with this. You need to give me my kids. But get a court to say, ma'am, that's not right. You're in contempt. I know here in New Hampshire, it's a reason to change custody. So if somebody's completely interfering with your parenting time frequently and often, to that extent that the judge doesn't believe that they can follow a parenting plan, they'll just give the kids to the other parent.
Yeah, and I think, Mark, I would use this opportunity, again, get a consultation with an attorney, use COVID. I mean, perhaps her excuse is COVID related and judges are more aware and likely to, use that against her unless there's a legitimate health reason to do it. But time is not on your side. You can accumulate 52 police reports and the court's going to say you acquiesced, as Jessica pointed out. You really need to take action sooner than later. The quantity is not going to matter, but the quality will. And so definitely take action. And as far as the support is concerned, if you're paying something that should be covered, communicate in writing. Make a demand of your spouse, ex-spouse, and say, look, I'm paying this. I shouldn't be because it's already covered. You need to cover it and reimburse me. And when she doesn't respond, that can be used as well with those police reports. So seek an attorney. Obviously, we're available. We have offices all throughout Texas. You can reach us at 866-DADS-LAW or on the web at CordellCordell.com. So let's keep on going. Hutch in Virginia. Jacob, I'm going to come to you on this one. Interesting one. Wedding ring was purchased, and the 3 years, they upgraded it 3 years later, it looks like, substantially, $30,000 worth. Now she wants to keep it. The question becomes, gift, marital property, how are judges looking at that in Virginia in terms of the, upgrades, not the original ring, but perhaps upgrades? Are they going to count that as marital property? Does Hutch have a claim?
Yeah, so in Virginia, any property that is given as a gift to a spouse is going to be considered marital property. So while you may have given it to her, the judge may ultimately just award it to her since it was a gift to her, but the value of that ring is still going to be a marital asset and subject to division. So it's not to say that it's going to be exactly 50-50, but that's typically what we're looking at just right from the get-go with any marital property.
Agreed. And I think anything, you always try to find those aspects that affect someone in the settlement negotiation. So I'd always include it in the list and making sure that they know that I'm going to include it in marital property. And maybe you trade out something else if that's going to be a sensitive subject. And you don't include it, but you get 55% of the property. Somehow make it up. But there's a good strategy to be had here, Hutch. Again, speak to an attorney and we can help you out there. So let me go to Colorado. Dave in Colorado. I lost a contempt last year. I'm going to turn this over to Cassandra real quickly. I lost a contempt last year due to a public defender or just an independent attorney. Easy case for malpractice, but where's the process? How do I start that? And obviously you can find the local bar. I would imagine that's what I would do, Cassandra, is to try to get a referral for a malpractice case.
Yeah, malpractice doesn't fall under our family law domain. So we practice family law and you believe that your attorney has practiced malpractice. It is not something that a family law attorney is going to be able to help you with. The state bars. And as we talked about today, looking up reviews on attorneys that can help you with that. It's something that is important to do. It's just not something a family lawyer is going to do.
Yeah, absolutely. So yeah, I would just contact your local bar. They'll give you a good referral and you can start there. And I think that's the best place to go. So let me go to Robert. Robert, this is a multiple part question from Scott in Arizona. Scott's case is currently on appeal. Waiting for the respondent's brief to be filed. And there's a couple questions here. Is it possible, recommended, to seek a modification at the same time that the case is on appeal? And Scott doesn't say, look, I assume it's either child support or custody. But what would you suggest? And I'll get to the second part of his question about whether or not you can seek a modification while it's pending appeal.
So in terms of modifying child support, and whether or not you should seek a modification pending appeal, I think first let's talk about simply child support and how that modification occurs. at least in the state of Ohio, there needs to be what's called a substantial change in circumstances. And that is defined by statute as a upward or downward movement of child support by 10%, meaning Ohio has a formula that it uses to determine child support. If after using new numbers, the actual child support obligation differs by 10% either way from the prior order, then the court will deem it a substantial change in circumstances that warrants a modification. As to whether or not there should be a contemporaneous motion to modify pending the appeal, that's really going to be fact specific. Has there been a change while the appeal is pending? If there is a substantial change in circumstances, for example, if you, God forbid, had lost your job due to COVID, since the decision was pending in the Court of Appeals, I would undoubtedly say you need to file a modification in order to address the new facts that have come up.
Yeah, I think that's a key because, most of the time when you have these support orders, they're going to continue to accrue and you're going to continue to pay and you have to follow and abide by that order. So the appeal would only make things retroactive. So I think that if you've lost your job and that's an issue, you certainly are going to want to do something and take some sort of action. And then Scott's second part, Robert, is it prudent to seek enforcement order for things like visitation, communication, because they have a long distance parenting plan or joint decision making? Or is the court going to look down on, because it's a guy, that he may be a whiner and just is unhappy, and then just save it for modification? I mean, I know the answer here is no, but I'm curious. I mean, then you should seek it, right? What do you think?
Not only is it prudent, it's essential.
Yeah.
Deliberately withholding parenting time, although I might only practice in the state of Ohio, I can assure you that the deliberate withholding of parenting time is a factor that courts are going to consider in every single state in the United States.
Yeah.
That is a factor that they will look at and determine, well, are these individuals working together well enough? And if they're not, which one is more likely to accommodate the other? That is a big, big factor that courts consider, not only in enforcement, which was discussed like contempt and show cause actions, but for modifications as well. And I think by seeking enforcement, you're actually laying the groundwork, the foundation for the potential future case of seeking a modification. You want to be showing the court that this individual is not following this order, and it's not a one-off, that this is a habitual thing that she is doing. And that'll only serve to strengthen a potential modification case in the future.
Yeah, absolutely. All right, let me get to it on a child support question, a two-part question. I'm going to go back to Jessica on this, out of Texas. And the question really is, does student loan, or are student loans considered in child support calculations? Obviously, that's kind of implicating certain state laws with regards to emancipation. I'll talk a little bit about Missouri and what they would do. But Jessica, talk about student loans, or perhaps just maybe broaden a little bit and talk about the costs for college education and whether or not a parent can be required to pay for that.
So in terms of student loans and child support calculations, so the student loan, it depends whose student loans they are.
Mm-hmm.
So first of all, child support, at least in New Hampshire, is calculated on gross income. There is a reason to deviate from the guidelines if, let's say, one parent is taking on all the student loans from the marriage, maybe they're taking all the student loans from the kids, maybe their excessive debt load really doesn't allow them to pay the full guidelines, and applying the guidelines per the standard is really complex. It takes away all of their income. So there's a reason to deviate. So no, it's not used in the calculation. Yes, the debt burden could be a reason to get a downward deviation from the guidelines. So I hope that makes sense, because they're kind of two different trains of thoughts that they can run together, but at first blush, they're not considered in terms of the calculation. Does that make sense?
Yeah, it does. And I think from a Missouri perspective, and every state is different when it comes to college expenses for kids because of the emancipation age. For example, in Missouri, there was quite a while ago a Supreme Court case out of Missouri that said that divorced parents are required, and they use that word, required, to contribute towards the college educational expenses of their children based upon in-state tuition, right, at that time, but no more than 8 semesters. And so that could be considered, it could be if it's silent in your decree, it could be a modification. and they could come back, you could go back to seek contribution. So I would encourage you to go get an attorney, obviously, and have that consultation to make sure. And then the second part, Jessica, was daycare expenses. Our daycare expense is part of child support, and I know they are in Missouri, probably in most states, but talk about in New Hampshire.
So in New Hampshire, the child support calculation worksheet does take a deduction for child expenses. So if you pay $900 a month for one kid in daycare and you're the paying parent, you're going to get a deduction off of that. It's not dollar for dollar, but it reduces your gross income for the calculation. So if you're making $5,000 a month, it just reduces your adjusted gross income, which is kind of like taxes, that the percentage of child support you pay will be based on a lesser amount of money. So you do get a credit. It's not dollar for dollar. It's not, I pay 900, I get paid 900 less. It's just, you do get it reduces your gross income.
Yeah, and on the daycare issue, it's one of the things, again, write this down. I like to recommend to my clients we have the ability to take it off chart or out of the calculation when you pay daycare, because your child's not going to be in daycare forever. If you include it in the daycare chart formula, it's going to require you to go back and modify it, more attorney's fees. I don't want you to have to pay me to come back. So what I want to do is pay it separately. So it says you pay X percent or $500 until, as long as the child's required to use daycare, meaning that there's all kinds of strategies to use, but have that as a conversation point to make sure you're not just following the chart unless the court requires you to do so.
Well, and Scott, that's the interesting thing about California is in California, for child support, you have a set number based on your gross income. After that, there are what we call mandatory add-ons, and childcare is one of them, where each party is required to pay 50% of all daycare and uncovered medical themselves. It's not even included in the calculation. It's a separate amount you have to pay.
Yeah, that's the way it should be. Or uncovered medical or extracurricular activities, something incurred by agreement. That's, you just want to make sure you're not forcing yourself to come back and spend thousands of dollars again to modify something that could be so simple and taken care of by your attorney and overlooked. Again, I could go and list 10 mistakes attorneys make when divorcing their clients. Maybe that's another topic we'll talk about, but this is something to write down. So Jacob, let me come to you. Bob in Utah has a question. Can I, as the physical custodian, deny court-ordered parenting time due to the pandemic? And that's really the question is, so we have Bob, who's a primary parent, residential parent, and wants to know if they can deny court-ordered parenting time due to the pandemic.
So typically I'm going to tell you to follow the order, right? We had just talked, Robert was saying, you don't deny the other parent parent time. And what we've talked about a lot is here during the pandemic, if there is a legitimate health reason for not taking the kids over, for instance, if mom told you that she has COVID and it's her time, you probably don't take the kids over. But that'd be something, if you have that legitimate concern, I would certainly speak with her about that. But otherwise, unless there is going to be a major health issue, I think you follow the court order. And if you feel like you need to change it, you start a modification action to get things moving at that point.
Yeah, and I think it's also about communication, making sure you're communicating with your ex, saying, hey, my understanding you've been exposed to COVID, you have COVID, I have concerns in health, and opening that door so that, it's not a he said, she said, because guys lose when it comes down to that. So good advice, Jacob. So, hey, Robert, I'm going to come to you. Chris in Texas, or Christopher in Texas. My children are endangered by my spouse's drinking and driving with our children, not just drinking and driving, but with the kids, it appears. And he has evidence to support it. I've confided with my 17-year-old son discussing facts we both have witnessed independently. And then he goes, adultery by spouse after separation, but living under the marital home. Will these things adversely affect custody one way or the other? So 2 parts, drinking with the kids and driving, obviously, and then adultery, marital misconduct after separation, but in the home. Do those affect anything?
Yeah, great questions. Let's talk first about the drinking, and it kind of is a good segue from Jacob's comments about COVID. You know, it might be a formal environment going to court, but we do not check our common sense when we walk in the door. And if it's mom's parenting time and she comes to pick up the children and she is noticeably intoxicated, I would never advise somebody to simply follow the order. You do not check your common sense. And so in a scenario like that, you do not allow the children to go. Now, in terms of moving forward as to the drinking, I think there needs to have been an immediate filing yesterday to address this with the court, a motion to suspend a parenting time based on her drinking, a motion to implement some sort of a safety precaution to ensure that she doesn't drink. But alternatively, she cannot be seeing the children while intoxicated, certainly not traveling with them in the vehicle. The second portion, at least in Ohio, in terms of adultery, you know, most states that I've come in contact with are no-fault states. Although they might require a reason to get divorced, you can't just get a divorce willy-nilly. The reason for the divorce is not going to have an impact as to any of the property division. In terms of her behavior as it relates to custody, I will say that a parent's behavior in terms of adultery could have an adverse impact on their custody. Certainly if some of these rendezvous are happening in and around the children, that'll be towards her judgment and to the best interest of the kids. Mm-hmm. So without knowing the specific facts of your case, I will say that her adulterous relationship is likely to have little impact on the division of marital property, assets, and debts, but could possibly, depending on her behavior, have an impact on custody.
Yeah, and I think, and Christopher came in and suggested drinking and driving before separation and visitation. So I believe if we're in Missouri, certainly I'm going to use that information, whether it's currently ongoing. I'm going to use it to show a pattern of behavior that, you know, post-filing correction may not be permanent. It's going to show poor decision-making, you know, and so I'm going to use it. Of course, it's going to have an impact on the judge. Most of the time I'm bringing up evidence and facts to make an impact on the judge, whether or not the law allows it anyway. You know, that's the point of a jury. If you think about it, I used to do jury trials in you know, early in my career. The point is there are certain things you can't say to a jury. That's when you have these conferences with the judge, you have objections, but the point is you can throw that out. The judge is the jury. And the judge can say, you know, I'll disregard that. But the point is you've already planted that seed. So Christopher, absolutely, that evidence should be used. And again, to end on this note, you don't want to sit around and allow it to continue to happen. Call the police. I've had a client call the police when, you know, mom's pulling up. If that's still happening, pull her over. I know it's a tough one, especially with your kids there, but you got to do everything you can to protect them. But if it's not happening now, it happened before separation, certainly it's going to be used. Have that consultation with your attorney. Your attorney will tell you that. At least in Missouri, I can tell you that. We have offices throughout Texas, and you can certainly get with us at 866-DADS-LAW. That ends our town hall for August. Thank you for joining. Don't forget, visit us at CordellCordell.com. Submit your questions, if we didn't get to them, at coronavirus.divorce@CordellLaw.com. I'll address those in my weekly podcast that we hold 2 days each week. We'll be back in September with another virtual town hall. You'll have an opportunity to ask your questions live of our panel and get answers. Thanks for joining. Until next time.